First issue to consider is the question of whether the claimant was dismissed because of his age. The age is set out, the relevant provisions are set out in Section 5 of the Equality Act and Section 13 of the Equality Act. I know my learned friend is going to be dealing with that, so I will leave that in his good hands. But on the best reading of the respondent's evidence, it cannot be disputed that age was a factor in his dismissal. It wasn't the primary intention, but it was clearly a factor. However, the respondent maintains that it wasn't justified in his action to dismiss. The test is set out in a recent case of Selden and Clarkson, Wright and Jakes partnership, and the reference to that is 2012 United Kingdom Supreme Court 16. That is a case which involved interestingly enough, a solicitor who was required to retire from his partnership at 65. He was not at all happy about that, and he took his former partners to the tribunal claiming age discrimination on the basis that they were seeking to impose a standard retirement age on him, notwithstanding that the law had moved on from that at that time with partnerships and since then with employees. The case law was examined by Lady Hale, who gave the leading judgment, and the test that she set out is that the United Kingdom has chosen to give employers and partnerships the flexibility to choose which objectives to pursue. This is in the question of legitimate. The question, of course, is whether there was a legitimate objective in dismissing the claimant. And the United Kingdom has chosen to give employers and partnerships the flexibility to choose which objectives to pursue, provided always that, one, those objectives can count as legitimate objectives of a public interest nature. Two, are consistent with the social policy aims of the state. And three, that the means used are proportionate, that is both appropriate to the aim and reasonably necessary to achieve it. And this being a case of direct discrimination, therefore, the needs of the business are not paramount. In fact, they may not even be relevant, although I would argue that they must be relevant, if for no other reason than that it is in the public interest for businesses to be able to function properly. But what are the legitimate objectives of a public interest nature consistent with the social policy aims of the state involved in this case? The respondent submits that the following are legitimate objectives for that purpose. One, that businesses are and that they remain insured against potential risks to employees or customers. Secondly, that a healthy and safe working environment is maintained for all employees, including the claimant. Thirdly, that after a certain age, there is a public policy in not requiring employers to dismiss for incapacity, which may be humiliating to the employee, and at the same time, and this is linked, avoiding disputes about the employee's continuing fitness for work. Those last two are specifically referred to as legitimate objectives in Selden. The first two, the insurance and the health and safety, are matters which, in my submission, must be considered of a public interest nature. Was the means used in this case proportionate? In other words, was it appropriate and reasonably necessary to dismiss the claimant? And what is clear from the evidence is that the respondent was perfectly happy with the claimant until the accident. They did not consider him to be too old for the job, they having only employed him the year before. ability to do the work required until the accident. That was the wake-up call for the respondent, not his age, not his competence, not his attitude and general ability, but the fact that he had injured himself performing a routine task in a routine manner and in circumstances which not only were likely to recur if he had remained employed, which could easily have caused injury to others. It is wholly unsurprising, therefore, that they sought guidance from their insurers. They may indeed have been under a duty to report it to their insurers, that being an accident at work. And they did not welcome the advice they got from their insurers. They argued against it. They resented it. But that advice faced them with two unpalatable alternatives. The respondent could have either the claimant or it could have insurance, but it couldn't have both. It is submitted, therefore, that in the circumstances of this case, the reluctant dismissal of the claimant was not only proportionate, it was the only reasonable option allowed to them. Similar issues apply to the question of unfair dismissal. If it is held by the tribunal that the respondent was justified in dismissing the claimant for the purposes of age discrimination, it is difficult to see how it can go on to conclude that it was substantively unfair for the purposes of the unfair dismissal action. Given that the respondent has already admitted in the ET3 that the claimant's dismissal was procedurally unfair, the tribunal would then have to decide how long it would have taken for the claimant to have been dismissed had a fair procedure been followed. Given that there have been no complaints about the conduct of the appeal and about the claimant's ability to marshal and present his case at that hearing, it is submitted that the appropriate length of time can be fixed by reference to the length of time taken to arrange the appeal. As such, no losses would flow after that. I should mention, though, that strictly speaking, that is a matter for a remedies hearing in the event if the tribunal finds that liabilities have been established, and will also be complicated by the fact that the claimant has asked for reinstatement as well as compensation.
Thank you, Mr. Living. Mr. Emerson.
Well, it looks like I've been left to deal with the Equality Act and the definitions under that, so I'm very grateful to my learned friend for doing that. The first, I think we need to just go through some key concepts. Age is now a protected characteristics for the purposes of the Equality Act 2010. And Section 5 of the Equality Act provides a rather tortuous definition of age for the purposes of the Act. Apologies for this. It provides that a reference to a person who has a protected characteristics is a reference to a person of a particular age group. B, a reference to a person who shares a protected characteristic is a reference to persons of the same age group. And C, a reference to an age group is a reference to a group of persons defined by reference to age, whether by reference to a particular age or to a range of ages. So what does that mean? Well, I think we can deal with it quite simply in this case, in that the fact is the claimant is 65 and could reasonably be described as being of traditional retirement age. Now, Section 13 of the Equality Act provides us with a definition of direct discrimination, and it's direct discrimination that we're dealing with today. And that is defined as where a person A discriminates against another B if, because of protected characteristics, in this case age, A treats B less favourably than A treats or would treat others. Now, on the facts of this case, you can be satisfied that the reason for the dismissal was effectively caused or significantly influenced by the claimant's age. And this is very much the reason why Mr. Bunch dismissed the claimant, because he assumed that the job was too difficult for someone of his age. This belief was a significant factor that motivated his actions. The respondent would not have acted in this way if they were dealing with a 25-year-old. Age also appears to have been a in why an approach was made to their insurance company and why the insurance company decided to withdraw cover for the claimant. Now, age is unusual under the Equality Act in that there is a defence provided by Section 13(2) of the Equality Act to direct discrimination if the employer can show that the treatment is proportionate means of achieving a legitimate aim. Now, my learned friend has already given you the reference to Selden, but this issue was considered by the Supreme Court in that case, and I'm not going to go through the facts again because that's been dealt with by my learned friend. But in the actual decision itself, Lady Hale, who gave the leading judgment, made it clear that in order for an employer to justify direct age discrimination, the aim of the measure must be for social policy objectives, such as those related to employment policy, the labour market or vocational training. It's important these are areas of public interest as opposed to the individual reasons particular to the employer's business. And it is for the employer to actually identify the legitimate aim, the social policy, and then satisfy you that it is legitimate in the particular circumstances of the employment concern. But further, that the means chosen to implement the aim are both appropriate and necessary. So even if you were to accept that the actual argument can be made out by the respondent that the dismissal was on social policy grounds, the respondents would have to go on and actually satisfy you that the dismissal was both appropriate and necessary. And the difficulty that the respondents have in this case is they've not provided any adequate evidence to substantiate their belief that it was not possible to obtain insurance from another insurance company. In fact, their evidence didn't even go as far as that. They didn't even try. It might have been possible. We just don't know. In my submission, that's not good enough. The burden of proof rests upon the actual respondent to establish that their actions in dismissing Mr. Monty were both appropriate and necessary. And lastly, just dealing with capability, there is no real evidence in this case that the claimant was unable to carry out his work efficiently or that his productivity was likely to decline as a result of the back injury. As a result, this is not a case whereby the respondent can legitimately argue that he dismissed the claimant to preserve his dignity. Dealing with the unfair dismissal matters, I'm going to be very brief in relation to these matters. If you were to find that the dismissal was discriminatory, then the dismissal itself must be unfair for the following reasons. Firstly, no reasonable employer would dismiss an employee for a reason that amounted to direct discrimination. And secondly, no tribunal could consider that an employer was acting fairly in dismissing an employee when the reason for dismissal was tainted by discrimination. Accordingly, the issue of whether correct procedure was followed becomes rather irrelevant, and no deduction can be made on this basis. However, if you do consider that the dismissal was not discriminatory and are satisfied that the dismissal was for a fair reason and that dismissal was inevitable, it is accepted that the period of compensation would be limited to a period of 4 weeks, representing the period of the time that a fair procedure would have taken. Unless I can assist you any further, those are my submissions.
Thank you very much, and I'm grateful to both counsel for the timely way you have dealt with this hearing today. Right, that's the formal part of the afternoon over. We're going to take a short adjournment now, where we, the panel, will consider... In relation to the vote, they have been counted and independently verified. I've got to get out on a Saturday night. And 84 of you thought that, yes, this was a case of age discrimination, and only 25 of you didn't think it was. I'm guessing that 25 are all under 40.